First up, we're in Ann Arbor, Michigan for a bond violation hearing. 56-year-old Tracy Reed has been charged with possession of firearms and possession of a controlled substance. A year earlier, Reed, whose previous convictions include having a concealed pistol in a motor vehicle, was arrested, had a plea of not guilty entered on her behalf, and was released on a $5,000 PR bond with several conditions, including that she not leave the state without the court's permission and report to community corrections for a 2-day intake appointment. But after she missed the second day of her intake, Reed was summoned to court. Today, she appears before Judge Cedric Simpson to find out if her bond will be revoked and if she'll be sent to jail. Reed is represented by public defender Davi Lebo.
Your Honor, Ms. Reed indicates to me that she did do community corrections on the 11th. However, on the 12th, she was unable to remain as she had to go to work.
So I have no test results.
No, I took the test results. It's right here. I took the urine.
Well, the one,
Yeah.
but since then I don't have anything.
He only told me to drop once a month.
That's correct, but how were you going to go back if you didn't do the intake?
I didn't know I had
How
to
are
do
you
the
gonna-
intake in order to keep dropping.
What?
No, it's judge, but that's okay.
Okay, I can't go to jail. I
No,
can't.
you can.
I'm too old for that. That's. I can't. Please. I just got my good job.
I'm not going to lock you up today. The only reason I'm not doing is run monthly tests. You're still within that month, and the test that you took was negative.
Absolutely.
Judge Simpson gives Reed a break and allows her to remain free on bond if she reports for her intake appointment after the hearing.
Now I have another question.
Oh.
Before all of this happened, I had plans to go out of state for New Year's. So I need the permission to go, because this has been planned and paid for.
Where are you going?
To New York to watch the ball drop.
You're going to go watch the ball drop?
Yeah.
Where?
From, what's the name of it?
Like Times Square?
Yes, down by Times Square. We stand in a room.
Gonna be outside watching the ball drop?
Not if it's real cold. I'm hoping we can see it from the
It's
hotel.
gonna be cold.
Counsel, you were here in order to the effect, unless there's an objection from the people, to let her go watch the ball drop. Bye.
Okay.
Reed gets her bond continued and permission from the judge to travel out of state. Her case is pending. Next, we head to Leelanau, Michigan for a bond hearing. 42-year-old Caleb Moses Peard has been charged with assaulting, resisting or obstructing police, and harboring felons. 2 days earlier, police say they arrived at a residence to arrest Peard on a warrant for a bond violation in an unrelated drug case. That's when they say Peard resisted, was arrested, and charged. Today, he appears before Magistrate Noreen Castis to hear if he'll be released on bond for his most recent charges. Peard, who also has pending drug and domestic violence cases, is represented by attorney Paul Jarboe.
So, Mr. Jarboe, have you had an opportunity to speak with Mr. Peard regarding the charges, the possible sentence, and his Miranda rights?
Yes, so we reviewed the felony complaint. He's aware of the counts and the potential penalties under Michigan law. He's simply asking that pleas of not guilty be entered on these counts.
Right, this brings us to bond setting on this case. Mr. Jarboe, did you have anything you'd like to say about bond?
Well, Mr. Peard indicates that there is a hold on him from Charlevoix County for a probation violation for which he would like to have taken care of. He would ask the court to consider a PR bond in this matter so he could be released to Charlevoix, so that he could go to Charlevoix and get his matter resolved there.
All right, thank you. Well, given the fact that you had a couple of failed to appears here, one being the FOC case in Grand Traverse County?
Yeah, that one I missed by 2 hours, ma'am. I got the time messed up.
Okay, well,
Like, I called them at 11 o'clock in the afternoon instead of 9 a.m.
okay, well, that was back in July. This
Yep.
is back now October, so you've had plenty of time to take care of that by going.
Oh,
there
yeah,
and
but
take
I
care of
called
it.
him. He told me if I
Right.
didn't come up with
Yeah.
$25,000, he'd release the warrant. So I didn't come up with $25,000. I didn't get the warrant.
Okay, okay,
I mean, I
but,
really don't give
okay, let's keep our language a little cleaner, okay, sir?
Yep.
Thank you. All right, so we're gonna set this as a $10,000, 10% bond.
So $1,000 will get me moved to Charlevoix.
$1,000 we get you to Charlevoix. Yeah.
Get me out of here.
We're not
I'm
done.
this dumb
We're not done yet.
Picard does not seem happy with his bond amount.
We're not done yet.
We're done.
No, okay.
We're done. You told me
You're done?
$1,000 to get me out of jail. I'm done.
Okay, sir, you're not gonna have that bond if you don't sit down.
I don't even want the bond.
Okay,
Do you think I can come up with $1,000 if I can come up with
Sir,
$400 to get out on child support?
you're getting credit for time served.
Good
Let's
deal.
finish.
On some charges that are some bull.
Okay, sir, would you like a bond or not like a bond?
I would love a bond.
You would
I
love a
love a
bond?
PR bond so I can go up there and deal with my
Okay, I'm gonna mute you because I'm gonna go through the conditions of this bond, okay? Thank you. Now, you're not to have any contact with and to stay 500 yards away from
Love
where
you
you
too,
might
lady.
be during the
Why am I not allowed to have
pendency
contact
of
with her?
this bond.
Why am I not allowed to
Your
have contact with
court-appointed
her?
attorney,
No, hold up.
Okay,
Why am I not
sir.
allowed to have contact with her?
sir,
Why
your
is that a condition on
court-appointed
the bond?
attorney,
I'm done. Get me the out of this house.
okay, no bond.
The magistrate has just rescinded the defendant's bond.
So, Mr. Jarbo,
Okay,
thank you for trying to assist with this particular client.
you did a good job. All right, thank you.
Picard remains in custody without bond. He's pled not guilty, and all of his cases are pending. Next, we go to Trenton, Michigan for a hearing. 43-year-old Jamie Pratt has been charged with driving with a suspended license and equipment violation. 2 years earlier, police say they spotted Pratt driving with a busted headlight, and when the officer learned she also had a suspended license, she was cited and ordered to appear in court. But when Pratt was a no-show, a bench warrant was issued for her arrest. It remained active for 2 years until she finally appeared in court, pled not guilty, and was released on a PR bond. But when she failed to appear a second time, another warrant was issued. Today, she's set to appear remotely before Judge Michael McNally to discuss next steps in the case. Pratt is represented by defense attorney Dion Patillo.
She stands mute and waves reading, Your Honor.
Hang on. Ma'am, I don't know where you are. You're gonna have to stop. I need to see you. You're not driving, right?
No,
You're
I'm not driving.
This case been going on since 23, Ms. Pratt.
Okay.
All right? It's way too old for me.
It's just a warrant. Everything that the case was about, I did the first ticket. I have my license. It's just a warrant that's holding me up. Anything that's involved in this case has been done.
It's just a warrant. Is that what you said?
It's just a warrant. That's the only thing that has to be there. I have my license are valid. That I don't even have that car, but I got the headlight fixed like within the week of me getting the ticket.
Ma'am, I'd suggest that you at least acknowledge. I know it's impossible for some people to say.
Acknowledge what? That I got the ticket? I did get the ticket. My headlight was out. My license was suspended. I'm not denying that.
It seems Judge McNally has heard enough.
We're going to give her a new date for an arraignment and pretrial. Defendant has to appear in person.
But that's not going to be able to happen.
Well, then you're going to have a warrant issued for your arrest again.
Because I can't come into the courts?
Hey, listen, I don't want to do anything to inconvenience you here. I don't want to inconvenience you. Give her an in-person date. I'm not going to play this game.
Me either.
The defendant leaves the hearing.
She's gone, Judge.
What an attitude. What an attitude. Case is outstanding since 23, and it's just a warrant. So she stood mute on both. I'll set the bond when she comes in, okay? November 12th at 8:30. Jeez, what is happening? Huh? Can you tell me what's happening? No, Judge. I don't want to know.
Pratt did not appear at her subsequent hearing, and Judge McNally issued another bench warrant. The case is pending. Next, we head to Lansing, Michigan for an eviction hearing. 38-year-old Chase Carson and 39-year-old Amanda Williams owe nearly $10,000 in back rent. A year earlier, the couple's landlord filed a termination of tenancy complaint, and the court ruled in favor of the plaintiff. The defendants were ordered to appear for a debtor's examination to determine how the back rent would be paid. And today, both defendants appear remotely and without an attorney before Judge Kristen Simmons to discuss next steps in the case. The plaintiffs represented by attorney Jessica Larson.
Today was the date scheduled for a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade.
Let me stop you because I'm just getting updated on this case. Let me also be clear. I don't make decisions because I'm emotionally charged. Don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let
I run the courtroom.
Okay, I understand.
Judge Simmons moves on to the unpaid balance.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor. I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered.
Okay. Are you in a position to pay in full the past due amount?
I prefer a payment plan, and I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers despite what she had just told you. Can she produce an actual number, or are we going off of what she thinks?
I mean, I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
By now, the judge seems to have heard enough.
You can do one of two things, sir, because I'm not the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter.
Your Honor, save yourself the time. Have her fact.
Don't tell me what to do. You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. Do you understand that?
I'll pay the balance.
Thank you. Any additional matters for the record?
No, Your Honor. Thank you very much.
The defendants paid their outstanding balance, and were allowed to remain in the home. The case is now closed. Next, we're in Macomb County, Michigan, for a child custody hearing. 34-year-old Lori Estabrook is suing her 37-year-old ex-boyfriend, Roland Owens, for custody of their 7-year-old daughter. 1 month earlier, Estabrook filed for sole custody, claiming that Owens refuses to hand over the child at scheduled times and withheld a medical device that the child needs to treat diabetes. Today, both parents appear virtually before what is called a friend of the court judge, Brian Nicholas, for next steps in the case. Estabrook is represented by attorney Jennifer Lindquist. Owens, who's representing himself, claims he hasn't had visitation in a month and has filed a one-sentence motion asking to see his daughter.
All right, so Mr. Owens, your motion is only one sentence. Just says, to see my daughter that is being kept from me unlawfully. You're supposed to file a motion and indicate specifically what you're asking for, meaning the schedule, custody, parenting time, and what you're asking for today and why.
I just want to be able to see my kid.
Okay, you have some you want to hear, but there's also procedure and notice requirements and how you have to prepare things. I get that you guys want to resolve.
Procedure when they came and took my kid.
Stop, Mr. Warren, you got to take a breath. You got to listen to me. Miss Estabrook, is there a reluctance to have contact between him and your daughter?
Yeah, because he withheld her diabetes receiver hostage for 3 days when she's a type 1 diabetic and it's life-threatening.
No, I did not.
The police.
They stole her from me.
Mr. Owens.
They came and stole her from my house the day of her birthday party. I had called the police, told me I was not allowed to come to her birthday party. And Miss Estabrook and her boyfriend now have. I don't want her boyfriend around my daughter because she is a type 1 diabetic, and that's a compromise to her immunity.
Okay, just a second.
As the judge takes a moment to gather his thoughts, Owens decides to take a cigarette break.
Smoking a cigarette on Zoom, Your Honor.
It's remote, it's in a car. I got a thick skin. It doesn't bother me.
Judge Nicholas adjourns the hearing to give Owens time to resubmit his motion.
As this is a custody case, neither party has the right to enter into each other's household or onto their property absent an invite from the other party. You can't walk in each other's houses. You can't. Well, I'm saying in the future,
they
guys,
walked in my house and took my daughter.
Stop, Mr. Owens. Listen, you got to calm down.
This is my daughter we're talking about. I'm not a part-time dad.
Okay. Both parties shall submit to a 9-panel urinalysis drug test within the next 24 hours.
Really? Wow. What about a medical test for her?
It's all irrelevant.
How is it irrelevant?
I don't know.
Has nothing to do with parenting time.
Wow.
All right, guys. You have 21 days to object. Okay?
So
you guys are all set.
6 months later, Owens refused to participate in a hearing to determine custody and support. The judge granted Estabrook sole legal and physical custody of their daughter. His visitation rights were also suspended, but Owens must still pay $581 per month in support. He has the right to appeal, but for now, the case is closed.